Assistant Professor Mahdev Mohan.
Mr. Speaker, 15 years ago, when I first started looking into criminal litigation, there was a speech that was made by a senior member of the Attorney General's chambers. And the gist of that speech was, there is no such thing as an unmeritorious prosecution, only an unsuccessful one. That was the approach then. And I'm very happy to say that from what I can see, and from this particular bill that's before us, that is not the current mindset of the ministry. The ministry has proposed significant contemporary changes to the criminal justice system. It marks, in their words, a major step in the long-term move towards a more progressive, balanced, and modern criminal justice system. I celebrate that move, welcome it, and I declare at this point that I'm a consultant to the Criminal Practice Committee of the Law Society, and over the past several months, we have had an opportunity to meet with the ministry at all levels, several times, and we've done what lawyers do best. After these consultations, we followed up with copious notes and extensive submissions. So I will not go through every point that was raised. I'm just happy to note that quite a few of these points were actually incorporated in the refinements to the draft bill at that time. I will focus on a few points that I think we would like some clarification on, Mr. Speaker. Let me begin with video recording, please. Video recording, or the new section 225B, is welcomed because the idea that we would no longer have to spend in time, it begins with certain categories of offenses. The hope is in time, video recording may become a norm, as it is in other jurisdictions, including the UK. What that removes is the possibility that evidence was tampered with at an early stage, that statements were coerced through threat, inducement, and promise. That is the hope in time. But it's good that we at least have the possibility for video recording now. But I do raise a few points in relation to video recording in two separate respects. First, I ask from a very technical and procedural way, even though there's going to be video recording, is there a significant principal reason as to why this particular copy of the video will not be furnished to defense counsel and the accused person, him or herself? Is there a reason why a lawyer who has a professional responsibility as an advocate and solicitor not to disclose that recording in the public should be not provided this copy? If the fear is that a foolish or a crooked defense lawyer may disclose the footage, then perhaps could the ministry require defense counsel to sign an undertaking that they shall not disclose the footage? Would that not be sufficient? A breach of such an undertaking, of course, would be on pain of disciplinary penalties and perhaps even prosecution. So is there a reason why we would not disclose a video recording to the defense counsel themselves? I say this with full knowledge that the defense counsel will have an opportunity to actually look at the video recording at the police station or at a particular place that the minister so decides. But putting aside the additional resource burden that this will place on the police to make such arrangements for defense lawyers to view the video footage, could the minister confirm, for the record, that defense counsel will be able to review the footage as many times that they may want to, and at a time and convenience to them, maybe mutual convenience to the police and to them? I ask this because in preparation for the case, for the defense's case, viewing footage as to when the long statement and short statement, which is the first statements that are given to the police, are crucial for the preparation of the defense case, and often cannot be done by just looking at one video recording. Separate, looking at 264A that is being proposed, I'm looking at statements recorded through video as well, but the suggestion that in certain situations, Video recordings may even be used as a substitute or as a complement to evidence that's given in chief in court. The criminal bar, during consultations, has expressed legitimate concerns about the implications on the trial process if video recordings even partially substitute evidence in court or evidence in chief in court. When evidence is led, Mr. Speaker, leading questions are not permitted and can be subjected to on-the-spot objections. But this rule may not be practically enforceable in a video-recorded interview. The potential of an interviewer inadvertently prejudicing the evidence cannot be ruled out, especially if the interviewer is not a trained advocate. Many technical questions also arise. Will the video be shown in its entirety to a vulnerable complainant? Where there are breaks in the interview, will these be recorded and shown? Does the video that is shown in its entirety, if it is, show all the individuals that are present in the room at that time? These are nagging questions, Mr. Speaker, only because these are often the questions that are raised by defense counsel. At a point that there was no video recording, these are the questions that you will ask of your client, an accused person, to say, how did your interview process go? And after the questions are asked of the accused person, you prepare your case. Where there is an advantage of actually having a video recording, there will be questions that are asked if that recording for complainants of sexual offenses, for example, is going to be substituted for the actual evidence in court. Moving on, Mr. Speaker, to the evidence, and I'm looking at Clause 42, Section 166, which proposes Section 166 amendments. At present, Mr. Speaker, there is no further obligation on the defense to disclose a supplementary bundle of further information beyond what the prosecution gives. Let me give an example. The CCDC regime, which is the present situation, operates on a quid pro quo basis. The initial disclosure is by the prosecution, and then it's to be reciprocated by the defense. I understand that this is the basis and thrust of a lot of the amendments on discovery that are being put forward by this bill, but I have a few questions. If there is a requirement for the defense to disclose a supplementary bundle that must arise from the premise that both the prosecution and the defense have the same starting point. That is the wish for them to have a level playing field. But the truth, Mr. Speaker, is the resources are considerably different. The prosecution has the resources of the state. The defense often has a team of very few lawyers. I say this keeping in mind that the current practitioners in the criminal bar often are not pure practitioners of criminal justice. Those practitioners have probably a considerable practice in civil litigation and arbitration, and often the criminal practice or the criminal practice that is done by the more senior practitioners at the criminal bar is done pro bono or through class or LASCO. So how would we even up then the playing field? I say this also because the prior assumption, which was expressed by the Singapore High Court, was to assume this natural imbalance, to know that the prosecution has the resources at its disposal, that the defense might not quite have the same, definitely does not have the same resources, but may be inadvertently or by practice prejudiced. They don't have the same number of people, they don't have the same investigation. In the Singapore High Court case of So Guan Chu against the public prosecutor, this is what the court observed. The High Court said, in an adversarial system of criminal justice, it is not the prosecution's duty to assist the defense in making out a case, nor is it appropriate to allow the defense to trawl through lists of unused material in the speculative hope of finding a defense, while placing the burden on the court to decide on the relevance or credibility of those materials. The prosecution's overriding duty is to act fairly in the public interest and to assist the court. Surely this does not mean it must be placed in the invidious position of having to assist the defense to this extent as well. That was the position that was taken in that case. Allow me to conclude, perhaps, Mr. Speaker, with a couple of points based on a recent case which I had the opportunity of looking play out in court. I wasn't involved in this case, but I attended the Court of Appeal hearings, and I noticed an interesting point, and I say this in relation to perhaps Section 394K that is being proposed in the Criminal Justice Bill. This particular section has already been raised by speakers before me, and my honorable colleagues rightly ask one question: does it go too far? The Senior Minister of State said earlier that it does codify the current law, and she is correct, because it codifies the position that was taken in Kojia Bing by the Court of Appeal. But in doing so, actually looking at the test in statute, hard-coded in statute, and noting, as she mentioned earlier, that it is that test in Kojia Bing plus, which is how I'll refer to this test, Kojia Bing plus. So if that is the test that's going to be applied, there are a couple of questions that arise. Are there going to be certain terms of art that are going to be questioned again and again when we have a possibility of a miscarriage of justice? My honorable colleague, Mr. Heng, asked earlier whether if there is one try for a review, should that really prejudice or stop you from trying again? And I think the main idea is, will there be unfairness to the accused at any point? My hope is that the court will be able to actually intervene at that point and say no. If we think we want to hear it, we will hear it. But the question here is, are we sort of tying the hands of the court? I understand that we don't want to be inundated by unmeritorious claims. But what if one of these claims turns out to undo or reverse an injustice? Surely there must be a possibility to bring that before the court. And I compare this, therefore, to a particular case, this recent case that I mentioned earlier, 2018 case of PP against Mohammed Arifan, which was a class case, criminal legal aid scheme case, that was argued before the High Court. And at the High Court, the defendant was acquitted of charges, including rape and sexual offense or sexual violence. The prosecution is currently on appeal, so I won't go into the facts of this case since it's pending. But what is concluded is a criminal motion that was put forward as to whether fresh evidence could be introduced. That was a very tough case for the prosecution. The prosecution was trying to adduce fresh psychiatric evidence of a psychiatrist who had not actually examined the accused person. So the natural question is, why should such evidence be relevant or even necessary? And the answers were argued extensively, and ultimately the Court of Appeal said that the legal tests will not be changed, but having said that, there would be some evidence which would be useful in their determination of that case on appeal, and admitted some part of that evidence. If that is the approach that we are taking, Mr. Speaker, that the courts should be free, not handcuffed by the words in the statute, will there be any change in this current position? I ask this of the Senior Minister of State through you, Mr. Speaker. Finally, Mr. Speaker, and I conclude with this, in that case, what is important is that the Court of Appeal reminded us that it is a dire anxiety on the part of the court not to convict an innocent person or to impose a sentence that is out of proportion to the criminality of the offender's conduct. They tread very carefully to avoid any prejudice that could be suffered by an accused person who is wrongly convicted or who receives a manifestly disproportionate sentence relevant to their culpability. Criminal defense lawyers have a difficult but important role, Mr. Speaker. That role is not popular. That role is often criticized. Even it just happened in this House. Perhaps rightly sometimes. The criticism that came from my fellow colleagues was about cross-examination that oversteps the bounds. And certainly that must be struck down. But as that cross-examination is thought of and presented, the point is, people will ask, if I don't ask a particular question, which is within the bounds, which is not insulting or outraging the modesty of a complainant or a witness on the stand, if a particular question is not asked, will that somehow prejudice my client's case? And again, I go back to this Mohan Arifan case, where that became almost a question that was raised in this 2018 case. It went on the level of questions that were asked at the trial below, and whether a particular point remained a live issue, or whether that particular point actually was concluded substantively, such that the prosecution did not have a basis to raise it on appeal. All of these are technical points. But again, I say, it was a sexual offense case, it was a rape case. Questions never went or strayed beyond a particular line, never were inappropriate. But do we want to have a chilling effect on responsible defense lawyers, Mr. Speaker, to tell them, not just be careful, but maybe don't ask a particular question. Since you've made your case, don't ask that question. I don't think that should ever be the case, Mr. Speaker. With that, and notwithstanding those points, I support the bill.